Okay.
Yes, yes, yes.
Hello, everyone. Welcome to this last session on migration and law. We're going to discuss multilateral agreements. And we have a very special speaker today, Dr. Elisa Ortega. She's a tenured researcher at the Institute of Legal Research at the National Autonomous University of Mexico. She holds a PhD in law and a master's in public law from the University Carlos III of Madrid. She obtained a bachelor's degree in law from the Mexico Autonomous Institute of Technology, and she belongs to the National Research System of Mexico Level 2. She has been a visiting scholar at the University of Warwick, UK, the University of Chile, and she is currently visiting scholar at Temple University in Philadelphia. Her research lines are law and migration, asylum, refugees and forced migration, migrant children, critical legal studies, human rights, and public international law. Her last book is on asylum as a right in dispute in Mexico, race and class as a dispositive of exclusion. She coordinates the interinstitutional seminar, Critical Legal Studies and Migration, the diploma, Migration and Human Rights, and the research group Rights, Migrations and Mobility at the Institute of Legal Research at UNAM. So please welcome Elisa. We are really eager to listen to you.
Hello, everyone. Thank you very much for being here. I'm very happy to share with you some ideas regarding the origins of multilateral agreements regarding migration, especially the Convention of Migrant Workers, since it's the only multilateral agreement which focus on migrants, but in their worker phase, but also we know that all human rights treaties apply to everyone, every person. But at the UN system, we have seen that we have some human rights treaties which are divided on specific issues which are concern of human rights. For example, torture, children, women, etc. So I'm going to share with you my presentation so we can start. I believe you can.
Yes.
Yeah, perfect.
Okay.
Just okay. So let's see first, what about the concept of human rights? So let me move this. Okay. So what can we understand as human rights? So we have been told that human rights are the rights that all people have by virtue of being human beings. So they derive from the inherent dignity of the human person. So we do not differentiate if they are migrants, children, women, refugees, stateless persons. So human rights are for all persons. That's what the theory says. So they attach to all persons equally by virtue of their humanity, irrespective of race, nationality, or membership of any particular social group. That is, human rights belong to an individual as a consequence of being a human person. Human rights are a special sort of inalienable moral entitlement, but are defined internationally, nationally, and locally by various lawmaking bodies. So the term came into wide use after World War II, replacing the earlier phrase natural rights, which had been associated with Greco-Roman concept of natural law since the end of the Middle Ages. So the concept of the modern human rights is coined by Eleanor Roosevelt to replace the rights of men. We know now the modern theory of human rights states that human rights have dual nature, moral and legal. So human rights are more than legal concepts. They are the essence of men, and they are what make persons human. So this is why they are called human rights. Deny them and you deny men's humanity. That's what Jose Diokno has said. So human rights are defined as the supreme inherent and inalienable rights to life, dignity, and to self-development. After recognizing this, human rights are positivized in international, national, and local regulations. For these reasons, human beings have a moral power to hold rights to life, nationality, and property, rest, and leisure, to do rights to marry, peaceful assembly, run for public office, and education, to omit, and that this refers to the freedom from torture and cruel, inhuman, or degrading punishment, freedom from arbitrary arrest, detention, or exile, or to exact something. So equal protection of the law, equal access to public service, equal pay for equal work without discrimination regarding, for example, gender, nationality, etc. Let's see some characteristics which define the concept of human rights. They are universal, they are international, national, and local guaranteed. They are legally protected. They protect individuals and groups also. They cannot be taken away. They are equal and divisible. And they oblige states and states actors. So let's see now a more complete concept. Human rights are universal legal guarantees which protect individuals and groups against actions and omissions that interfere with fundamental freedoms, entitlements, and human dignity. So human rights law obliges states and governments and other duty bearers to do certain things and prevents them from doing others. It is concerned with issues in both areas of civil and political rights, and economic, social, and cultural rights founded on international accepted human rights obligations. Why human rights? The idea of these basic rights originated from the need to protect the individual against the arbitrary use of state power. Attention was therefore initially focused on those rights which oblige governments to refrain from certain actions. Human rights in this category are generally referred to as fundamental freedoms. For example, the right to life, the right to fair trial, and as human rights are viewed as a precondition for leading a dignified human existence, they serve as a guide and touchstone for legislation. Let's see core principles of human rights. Universal. This refers that all individuals are equal as human beings and by virtue of the inherent dignity of each human person. Inalienable. All people everywhere in the world are entitled to human rights. A person cannot voluntarily give them up, nor can others take them away from he or her. Indivisible and interrelated. That is, rights are completely interdependent and depend on each other for their effectiveness. Non-discrimination. Everyone is entitled to human rights without discrimination. Empowerment and participation. These rights endow people the power to claim them for their government, as opposed to charity, which is an act of generosity. Human rights are not charity. Human rights are owned by everyone. Also, we have another principle, accountability. Governments have certain duties and obligations to respect, protect, and fulfill human rights. So individuals and non-state actors also have duties to others. For example, employers related to their employees, which can be, for instance, migrant workers. The non-discrimination clause is a cornerstone of the human rights theory, the human rights law, and it's a dual obligation. It's negative, which refers that the state must not discriminate against specific individuals or groups, but it's also a positive obligation. So the state must take steps to identify vulnerable individuals or groups in need of extra attention to ensure their rights are guaranteed. For example, children. Children are entitled to enforced obligations from the state and other actors. For example, parents, NGOs, etc. When can rights be restricted? It's not the norm for the rights to be limited. They can only be limited in the following 5 criteria if the following 5 criteria are met. First, the restriction must be allowed for in law. Also, the restriction must respond to a pressing public or social need. Third, the restriction is strictly necessary in a democratic society to achieve the public social need. For example, in times of pandemic, many people have been restricted to travel regarding health issues. So these restrictions are based in this principle in the number 3. Also, there are no less intrusive and restrictive means available to reach the same objective. And finally, the restriction is based on scientific evidence, for example, the transmission of a disease as the COVID, and not drafted or imposed arbitrarily, that is, in an unreasonable or otherwise discriminatory manner. So let's see who are the rights bearers and duty bearers. So the duty bearer fulfills responsibility towards the right holders who claims the right from the duty bearer. And that's the circle of obligation and entitlement of the human rights. So the specific nature of human rights as an essential precondition for human development implies that they can have a bearing on relations both between the individual and the state, and also between individuals themselves. The individual-state relationship is known as the vertical effect. So let's see vertical and horizontal effects of human rights. Well, the primary purpose of human rights is to establish rules for relations between the individual and the state. Several of these rights can also have implications for relations among individuals. This is the so-called horizontal effect, which implies, among other things, that the government not only has an obligation to refrain from violating human rights, but also has a duty to protect the individual from infringements by other individuals. So the typical example is with in labor law, with employers and employees. So the employers have the obligation to respect labor rights to their employees, especially if the employees are in conditions of vulnerability. For example, if they are migrant, if they are women, if they are LGBT persons, etc. So the right to life does mean that the government must strive to protect people against homicide by their fellow human beings. So now, in this second part of this presentation, we are gonna study or talk about the International Convention of the Protection of the Rights of all Migrant Workers and members of their families. At the beginning of this presentation, I told you that the United Nations human rights system has many multilateral agreements which relate to specific issues on human rights. We have 9 core human rights treaties, and this is one of the most important human rights treaties, which is related to migrants, but migrants as workers. Also, as I already said, we have human rights treaties related to torture, to political and civil rights, to economic, social, and cultural rights, to enforce disappearance of persons, to elderly persons also. There have been some developments in the last few years. Also, we have a special treaty for children, of course, for women, the CEDAW, and of course, we cannot miss migrant persons. Migrant persons are very important in many areas, and of course, they should be taken into account in the multilateral treaties related to human rights. So let's see some of these specific international convention, which is in the UN system, because we don't only have a universal human rights system, which is that comes from the UN. We also have regional human rights systems. For example, in America, we have the Inter-American human rights system, but also in Europe, they have the European human rights system. And in Africa, they also have their human rights system. And in general terms, every regional system of human rights have the very similar treaties of human rights of the ones that have been issued or adopted by the United Nations. So this is specific, the Convention of the Protection of the Rights of all Migrant Workers and members of their family comes from the UN system. So let's see the main aspects of this treaty. So this treaty establishes an special report. Well, before that, I believe that you know that the UN system, they have a special commissions related to different specific areas. Of course, human rights is a very important one. So we have a UN Commission on Human Rights. Related to migrants, we have a special reporter on the human rights of migrants. Also, it's important to know that at this commission, there is a special reporter on trafficking in persons, especially on women and children. As you know, many migrant women and migrant children suffer from this crime, trafficking, human trafficking. So let's see about the convention. In December 1990, the General Assembly of the UN adopted this treaty, and it was open for signature by all member states. This treaty entered into force the 1st of July 2003. But the status of ratification is very poor. Issues related to migrants are delicate and are not comfortable issues for states because they usually see the entry of migrants as an intrusion of their sovereignty. So it's been a very difficult process, the ratification of this specific treaty. Regardless, it only addresses this phase of migrants as workers. So 56 states are party to this treaty as of today. So it's a very poor rate of ratification, as you can see, because, for example, the Convention of the Rights of the Child has been ratified by 196 states. As you can see, there's a huge difference regarding terms of ratification of these two treaties, and which related to those two groups in conditions of vulnerability, children and migrants. So we only have 56 ratifications as today. Let's see the scope of the convention. It's a comprehensive international treaty. It comes from the UN human rights system, the universal human rights system. It sets standards that are applicable in individual states parties. It reflects existing principles established by previous human rights instruments. For example, the treaties of 1966 related to human rights in political, civil, economical, social, and cultural rights are stated, these rights, in two very important treaties which were adopted in 1966 in New York. They are called the Covenants of New York of 1966. So this convention, the Migrant Workers Convention, repeats almost every right which is already stated in these two main human rights treaties, but related to migrants. Also, this convention defines the rights of migrant workers before departure, in transit, and in the country of employment. It establishes obligations for countries of origin, transit, and employment. It also states a definition of who is a migrant worker. It is stated in Article 2, paragraph 1. It says, a migrant worker is a person who is to be engaged, is engaged, or has been engaged in a remunerated activity in a state of which he or she is not a national. So, another important area which the convention states is who are regular and who are irregular migrant workers. In Article 5, migrant workers are considered regular if they are in a regular situation, if they are authorized to enter, to stay and to engage in a remunerated activity in the state of employment pursuant to the law of that state and to international agreements to which that state is a party. Who are irregular? Irregular migrants are defined in a negative form because this very same Article 5, paragraph B, says irregular migrants are those who are in an irregular situation if they do not comply with the conditions provided for in subparagraph A of the present article. So irregular are all those migrant workers who doesn't comply or doesn't have authorization to enter and work and stay in the destination country, which is the basic principle of this treaty, the clause of non-discrimination. I should add that this clause of non-discrimination is the basic principle of every human rights treaty, regardless if it comes from the universal human rights system or the regional systems. So the rights of all migrant workers, regular and irregular migrant workers, and members of their families are general human rights, such as the right to life, the prohibition of torture or cruel, inhuman, or degrading treatment, the prohibition of slavery, freedom of thought, conscience, and religion, freedom of opinion and expression, the right to liberty and security of person. As you can see, these rights have already been stated in the Covenant of Civil and Political Rights, which was adopted in New York in 1966. So this Convention of Migrant Workers is repeating those rights which have already been recognized for all persons, regardless they are migrants, refugees, etc. Also, and this is important, the convention states some rights which are specific human rights for migrants, which are very important for migrants. For example, it protects the destruction of IDs and other documents. Also prohibits collective expulsions. Also establishes the right to participate in trade unions. As you know, sometimes when workers are migrants, they are denied illegally the right to join unions. And you should know that every worker, regardless their immigration status, nationality, gender, nationality, race, religion, etc., they have the right to join unions and defend their labor rights collectively. So that's a universal labor right for all workers. And that has been stated, and it's also in another treaty, which comes from ILO, International Labor Organization. So we have a specific covenant which protects this right for all workers. Also, we have another very important right, which is the right to receive urgent medical care. We know that many migrants, especially irregular migrants, do not have insurance, health insurance, but they do have the right to receive urgent medical care, regardless their immigration status, according to this covenant. Also, the convention establishes the right of child to a name, to registration of birth, to a nationality, and access to education, because there have been many cases that the states, destination states or countries, deny children of irregular migrant workers the right to have a name, the right to registration of the birth, denying them all the rights that come with the nationality. That even in these times, almost all rights, despite what theory says, derive from the nationality. So we have seen these situations, for example, in Dominican Republic and Haiti, and with the children of Haitian migrant workers who are in irregular situation or status. So that's illegal according to this convention, and also it's illegal according to another treaties regarding children, for example. Because if states do not allow the registration of birth of children of irregular migrants, they put children in a state of statelessness. So it's very important to comply with this right. Now, this is a very controversial issue of this convention, because these conventions differentiate, as I already said, of irregular and regular migrant workers. So first, I explained the rights of all migrant workers, but now the convention states also the rights of documented migrant workers, regular migrant workers, and the members of their families. For example, the right to form associations and trade unions, to form associations, not to participate, which is a right for all workers. Also, the right to participate in public affairs and elections of their state of origin. Also, the protection of the unity of the families of migrant workers. This article has been contested because the right to family unity, it's a right for all persons, not only for documented migrant workers. So as you can see, this convention is important, but it also has many failures, for saying in some way, because it differentiates persons. It establishes this very important right of family unity only for documented persons, and that's not precisely accurate. Because if you see another treaties which have more ratifications than this, you can see that this right is for all persons. The convention also establishes a committee on migrant workers. The UN system, the UN human rights system, has its 9 core human rights treaties, and also an organ which is in charge of vigilate the adequate accomplishment of treaties. So in Article 72, it is established this committee, which is the body of independent experts that monitors implementation of the convention by its state parties. So this committee is composed of 10 experts, and the members are elected by state parties. This Committee of Migrant Workers held its inaugural session in March 2004. The committee examines states parties' reports and also cooperates with other UN agencies and intergovernmental organizations. Now, let's see which are the duties of states parties. These are established in Article 7. So states who are parties of these conventions undertake, in accordance with the international instruments concerning human rights, to respect and to ensure to all migrant workers and members of their family within their territory or subject to their jurisdiction the rights provided for in this convention, without distinction of any kind. That is, without discrimination. This is the non-discrimination clause. This is in Article 7. Also, in Article 83, state parties to the convention undertake to ensure that migrant workers whose rights have been violated shall have an effective remedy. They shall have access to the justice system of the destination country. Also, in Article 84, states are obliged to adopt the necessary measures to implement the provisions of this convention. These measures can be adopted in the 3 levels of government: in the judiciary, in the administration, and also in the legislation through the respective legislative process. Also, state parties should submit regular reports to the committee on how the rights which are stated in the convention are being implemented. Of course, we have many challenges of this convention, of this international treaty regarding migrant workers. First, the need to promote the rights which are stated in the convention. Also, removing obstacles to the ratification of the convention, because as you have seen, we only have 56 ratification of this covenant, and most of the ratifications come from the global South countries. Also, we have challenges regarding the implementation of this treaty, of this multilateral treaty. We say that they are multilateral treaty because in the ratification and adoption and also in the sign are involved many countries. So we have many challenges regarding the implementation, because on the one side, a country can ratify this convention, but on the other side, this country needs to do certain actions in the 3 levels of government, as I already said. So I would like to finish with this so we can discuss your questions and your concerns or your comments more in depth. Thank you.
Thank you so much, Elisa. It was really enlightening and I really like your explanation starting from human rights. I think for all of us is maybe something not really familiar. So I like this human rights approach, how the history of human rights, how they replaced natural rights, why human beings have more power, these rights to non-discrimination as a dual obligation. And of course, this description of the International Convention on the Protection of the Rights of Migrant Workers and Families is also very useful for all of us. I would like to comment on, or maybe ask you on 3 issues. One of them is this non-ratification process as a way out. So how can we reach agreements that are ratified more by countries? This is an issue in international law. The other thing I was thinking is about the migrant workers, the implications of talking about migrant workers. Some of them cannot be workers, that is the issue. And on the other side, even when migration is not always labor migration, it comes to labor migration because most of the people want or need to work. So maybe labor is a way to sort status out. I don't know if we can see it as an all-encompassing way of integrating migrant workers. And then the other more a third issue, more specific, is in international law, which agreements prevail, multilateral over bilateral, or bilateral over multilateral? I'm thinking maybe in situation between 2 countries, when the bilateral agreement is opposed to what the multilateral one says. Which ones do countries comply with? And I will now read 2 comments in the chat. Kimberly Watson says, thank you very much for this interesting presentation. Please, could you tell us a bit about what happens if states violate the human rights if they have ratified the treaty? What are the mechanisms for holding them to account? And Iman, she says, this is a very useful lecture. Is there a dedicated monitoring mechanism for this convention? Thank you so much. So if you like to answer this. And we have a comment also. Pushpa, do you want to open your microphone at once and then give the word to Elisa?
Thank you very much, Elisa. That was very helpful to know. My question has to do with, are there any consequences to the signatories if they violate these treaties, agreements, and so on? And what are they? Is there an example you can give? Thank you.
So now we can start with these first questions.
Yes, thank you so much for your comments and questions. First, I would like to say that in terms of obligations, multilateral agreements and also bilateral agreements, let's say they have the very same weight related to the state parties which are obliged. Let me put an example. A multilateral agreement involves many countries. And for example, in the UN system, these multilateral agreements, for example, related to human rights, were reached through a consensus of many states and through a very long procedure, which can take 5, 10 years, or even more. So they generally, at the UN level, they have a committee which is responsible. This organ is a committee which is responsible to vigilate that the convention or this multilateral treaty is comply. So states should report every year which have been their actions related to specific issues that the committee has already noted, and also regarding the general obligations of the treaty and, for example, here in the case of migrant workers. So bilateral agreements are another thing. For example, bilateral agreements can be an example, the Bilateral Agreement, which was signed between the United States and Mexico almost at the middle of the 20th century. This bilateral agreement was signed because the United States needed migrant labor, cheap, non-qualified labor, and Mexico was obliged to provide certain quantity of Mexican agricultors, journals. So this was a bilateral agreement. And this treaty was enforced just a few years, like 5 years or so. I don't have the exact number of years which was in force, but this is a bilateral agreement. I am trying to think this another example of bilateral agreements, but they have, I would say that they both, multilateral and bilateral agreements, create obligations, but they have a different nature. And the process is very different of adoption in a bilateral agreement, which involves, politics and specific international relations and diplomatic relations between two countries. And multilateral agreements are more complex because involve more than two countries. For example, the NAFTA treaty, this is a multilateral because it's 3 countries, Mexico, US, and Canada. But bilateral agreements related to very specific issues and needs of the two states which are concerned. So in the UN system, they have this mechanism. They have unconventional and conventional mechanisms of vigilance of the obligations which are stated in the human rights treaties. So when one person sees her or his rights violated, they have 2 options. One, to go to the conventional procedure. In this case, in the Migrant Workers Conventions, they have a complaint procedure and they have to fill a form and a procedure so that his or her case can be heard. And also there's an unconventional procedure which is in charge of the UN Human Rights Commission. But you should know that before a person can go to the international level, even though if we are talking about the universal level, which is the UN, or a regional level, which can be the Inter-American Human Rights System, or the European or the African system, they first need to go to the national justice system. This is a very important principle in international law. So international law is superior to the national justice systems. So persons first need to go to national systems to seek justice before they can go to these international instances. So it's quite complicated, I know, but this is a general principle. The superatory characteristics of the international human rights systems. So they first need to seek justice in the destination country, in the institutions of the destination country. Now I am reading.
Maybe we can give the word to Professor Bardui. I know she has to leave if she wants to ask her question.
Of course.
And then we go ahead with Diva and George.
Okay, thank you very much. The lecture is very interesting, as I said in my comments, systematic, and it situates the issue of migrants' rights in the overall dimension of human rights. I have a couple of observations, and we have learned, and I'm sure others would agree with me, quite a lot because you have given us details. Now, two questions that come to my mind is whether the sending countries, migrant sending countries, have any kind of programs whereby their migrants are educated about their not only human rights, but labor rights in destination countries, and the sort of channels that they have set up. I know there are consulates which are supposed to take these complaints, and the channels that they may have set up to enable migrants to air out, to voice out their complaints and the violation of their labor and human rights. The other thing that as part of the pre-departure, I don't know if we have any example apart from the Philippines, perhaps, I'm not too sure. Perhaps you could share some information or examples with us. If as part of the pre-departure package that the migrants are educated about what happens if you don't get your wages, what happens if you are made to overwork without compensation, what are your rights? I know most migrants go in a very precarious and insecure position. Excuse me, they're not supposed to complain as they might lose their, lose their job. In other words, how do we ensure that? This is a legal thing. Do migrants know that they can resort to some legal channels where they can voice out, they can organize? Is organizing part of their labor rights? In other words, in a foreign country, can you organize as workers to get together and say, if this is not complied with by the employer or the employer or in that destination country, how do we go about it? Are there any examples whereby this has happened? And could we get some information on that? Thanks very much. I have to leave shortly. Thank you again for a very, very educative lecture. Thank you.
Thank you, Raj. I'm going to try to speak very quickly related to what you have said. When you were telling us this, it came to my mind the case of Hoffman Plastic Compounds versus National Labor Relations Board in the US, which was a case which involved two Mexican migrant workers in irregular condition. Who were fired from the company because they joined a union. They joined a union which was opposite of the interest of the employer, of the company. So the company employed these two workers knowing that they were irregular workers, that they do not have papers. So when they joined this union, they were fired, not because of they joined this union, because of they didn't have documentation related to their work in the US. So obviously that was in retaliation of joining this union. So the company called ICE so that they could be deported to Mexico because they were undocumented. So the case then got to the next instance, that was the labor board in the US, and the labor board established that these two workers should be ratified in their positions at the company, because obviously they were fired because they joined the union, not because of the documentation, because knowingly the company employed them, knowing that they were undocumented. So the next instance in the federal court, put down this resolution of the labor board, and they said that workers should be deported to Mexico because they were undocumented, and that labor rights are below migration policy in the US. So at the end, the case got to the Supreme Court of the US, and the Supreme Court ratified the federal sentence that these two workers should be deported. They were in detention 1 year or so more. And the Supreme Court stated that national security immigration policy in the US prevails over labor human rights. So this is a very typical case of which involves, labor rights and immigration issues. And for this reason, the Mexican government asked for an advisory opinion in the Inter-American human rights system. So this was about in the year 2000 in the government of President Vicente Fox. So the Consular asked for this advisory opinion, which unfortunately do not oblige the US, but it is a guidance for courts in the US. So that was the form that Mexico could approach to this issue with a country, which is the United States, which does not comply any international treaty, and which obviously is not part of the Convention of Migrant Workers. So, so we have this advisory opinion of the Inter-American Human Rights Court. And also in this period, the Mexican government asked for a review of all Mexican migrants who have committed criminal activities and who were sentenced to death penalty. So we have more than 50 Mexicans convicted to death penalty, and their cases were reviewed, and it was found that there were fundamental violations to due process, and they were convicted without telling them their rights and without calling their consulate, in the Mexican consulate in the US. And then they never understood what they were told by the police officers, and they were found convicted to that sentence. So this case arrived to the international court, which is in The Hague, and also this court, which is in the UN system, adopted a sentence which declared guilty the US for violating due process of law to these 50 Mexicans who were convicted to that sentence. So at the end, the US decided not to comply with this sentence. The name of the case is the Avena case and others versus the US. And many of these Mexicans were executed, and some others were forgiven by governors through an instrument of like a feudal, instrument, which is called something like forgiveness. And Camelia, can you please help me? Clemencia?
Or maybe clemens?
Like clemens, yeah. Like
Clemency.
Clemency, yeah. It's a very odd feudal, instrument which U.S. governors have, and they forgive these very few persons, but because of this instrument, not because of the sentence of the International Court of Justice. So it's quite complex when we talk about migrants and criminal issues and also labor issues, violations.
Thank you very much. Thank you. And you see that there's nothing, you can't take a country to court. They don't want to do it. You just, this is where in the end you say, okay, these are guidelines, but really not much happens. And Camelia, if I can take one more minute and then I have to go. The case in point is what happened to migrants in the Gulf countries during the COVID time or otherwise. Their human and labor rights are violated. So even if they air them out, they're just thrown out of the country. So while we have these international conventions or the UN conventions, how can one make these countries accountable for? In other words, how can one show and say, this is where there have been violations and tolerated, knowing fully well the UN cannot take a country to court. Okay, the migrant has a choice, you stay or you leave. Okay, so this is but that does not mean that these things should not be demonstrated, because if there's pressure, and maybe I'm not going to say that the countries are shamed, because if you are signatory to a convention, you have to ensure that you abide by that. And there should be a way, and the lawyers are the ones, the legal people, who have ways of dealing with this, and to showcase these things. And I think the civil society has an important role in showcasing these instances. Thank you very much for a very insightful lecture. And thank you, Camelia, for giving me the opportunity to speak. Bye-bye.
Thank you for your comments and good luck in your other meeting. And then, okay, we have a couple of more questions, and maybe some of you would like to open your microphone. George, Iman, Elnura, Divya. Otherwise, I read the questions myself. Okay, I will go ahead and read the questions. The one from Divya says, in which point those rights benefit or not to criminal migrants? And the other question is, what happens if the migrant workers commit something illegal in the new country? Okay. George Nickel, he says, when irregular migrants' rights are violated, do they have any way to protest? And then Some people congratulate you for the lecture. Iman says, in the context of COVID-19 pandemic, there have been any recent cases relating to the right to urgent health care that you may point out for reference, please. Last one by Anura. She says, in Kyrgyzstan, for example, as one of the channels responsible for pre-departure support of labor migrants in terms of providing information on their human labor rights is private agencies for employment abroad, those that are registered and licensed. According to the national law, those agencies are responsible to provide such kind of info to send migrants by their agencies. However, the monitoring from state institutions is not clearly provided, and a number of agencies are not providing this. So, more hot issues to discuss, if you like to answer.
Yes. So when a migrant commits a crime, they generally have the right to have legal aid from their consulate. So there's a specific international and multilateral treaty which focus on this legal aid, and which is the Convention of Consular Relations, and it's from 1976, and it was adopted in Vienna. And this convention states in Article 36, I guess, that all foreigners who commit a crime should have the legal aid of their consulate. So this is directly related to the case I previously tell you, which is the Avena case, and Mr. Avena and others versus the United States, and which was resolved in the International Court of Justice in the Netherlands. So the US was sued by Mexico because United States didn't comply with this obligation, which is stated in the Vienna Convention on Consular Relations, to call the consulate, the Mexican consulate, so that they could provide some legal aid to these Mexicans who have committed crimes in the US. So this was a direct violation to this multilateral treaty, and that's why the US was sued by Mexico. So at the first instance, when a migrant commits a crime, he or she should call or ask for legal aid from their consulate. It depends also the net of consulates, which is in the destination country of his or her country. For example, in the US, the biggest consulate network is from Mexico in all the US, for obvious reasons. There's a huge migration from Mexicans to the US. So we have a very huge and the largest network of consulates in the US. So that would be the the first advice. Then when a crime or a violation of a human right is committed against the migrant, the first thing that he or she needs to do is to ask for justice in the national justice system before going to the international level. Because I already said the international level or the international justice system is supplementary to the national justice systems. The main reason is that the international system to access justice is very limited. It's not funded as the national or in general terms. So states ask first to go to national courts before going to the international level. For example, if you want to present a case in the Inter-American Human Rights Court, you first need to demonstrate that you have had a negative sentence of or a denial of justice in the national system of justice. So you cannot go first to the international level without seeking justice at the national level. So I just see a COVID question. Yes, of course, in the context of COVID-19 pandemic, there have been many cases related to migrants seeking urgent healthcare. But here I think that it mixes with also nationals of countries seeking healthcare. So it has been very difficult, I believe, to differentiate because many people is seeking nowadays, even nowadays, for healthcare. So in theory and in general terms, states should provide urgent healthcare to everyone. So I don't have any data regarding, migrants or not, at least now, migrants seeking for healthcare related to COVID, and they have been denied, access. I'm sure that there should be in many cases, but now I don't have any case in mind. So the last question, I'm reading the last question. Yes, in general terms, states who celebrate, for example, bilateral agreements related to migrant workers should provide, some information and practical education related to their rights in the destination country. For example, it's illegal to retain the documents, visas, passports of the workers. The employers cannot retain these very important documents of workers. But there have been documented many cases that, for example, in the US, they do that with Mexican agricultural workers. In the US, there are two programs for non-qualified workers, H1A and H1B. And they have this recruitment for workers for agricultural and also for services. And here is managed for the Ministry of Labor with the Ministry of Labor in the US. And well, they are supposed to have programs which train, the workers and to provide some guarantees. But in practice, what has been documented is that this, training, which is provided or which should be provided to workers, previously their trip to the US is not quite effective, and they have retained their documents, and there have there are many human rights violations. So I think that there are a lot of things to do in these issues, and there are many challenges to comply properly with human rights of migrant workers. And I think that would be all, Camelia.
Okay. Maybe Iman, she has a case herself. I don't know if you want to tell us about COVID cases, but because
Hi,
she's a
thank
doctor.
you.
Yes.
Well, unfortunately, I don't have a case, and I believe that we wouldn't be seeing cases in the immediate term.
Yeah.
My-
Maybe that's a good news. You don't have a case. I don't know.
Sorry, I'm a bit under the weather today.
Maybe that's
Um,
fortunate.
They might not surface in the immediate term, and that doesn't mean they don't exist, but as the years go by, we might see them post-pandemic, and there would just be lessons learned from the pandemic or something. But I'm keeping an eye, and I'm also looking at the convention that WHO is now working on regarding the pandemics and how enforceable would it be, because it's going to be an international law instrument, and we know that this is a pre-existing issue with international law, that its power of enforcement is sometimes not as strong as we would wish for. So these issues are still up in the air, actually. Thank you.
Thank you so much. Thank you so much. And then, well, we will finish now. Thank you so much, Elisa. I know you are not feeling so well. Pushpa, do you want to say something
Yeah,
before we finish?
sorry, I just wanted to, and this is a speculation that because there are so many problems with actually enforcing some of these agreements with countries that are supposed to be signatories to this agreement. And I'm just wondering if the international and UN particularly agencies have a way to impact greater participation of voters in the different countries. There are so many problems that we are encountering with restrictions on voting rights in the US, which I feel is also impacting how people can demand their countries, their nations to comply with these rights. And are there any ways, I'm sure there are non-governmental agencies and other agencies that are connecting the dots, but I was wondering if there is some kind of instance where there is implementation of the expectation for compliance by countries that are signatories. This is just, as I said, a question, and I'm coming from Georgia. As you know, Stacey Abrams has been doing a lot to help address this question in some, by appealing to the people themselves. And there is, I feel, a lot of education for the common masses in the destination countries regarding the rights of migrant workers. And that can only happen if we have the right kind of governance. That's my thinking. And I'm just speculating, as I said. I don't know if it can be implemented or are being implemented in any big way.
Thank you so much. Okay, I will give Elisa the floor. Just bear with us. We will have Paddy Singha, one of the program coordinators, when we finish. Just before we finish, to talk about the final work that you're going to do and the mentors. So please keep with us for a couple of minutes more. Elisa, please go ahead if you want to add comments.
Yes, well, I would like to say that related to Migrant Workers Convention, for example, there should be done two main actions. First, try to incentivize the ratification of other states. Well, nowadays it seems very difficult because of the pandemic and the every day more anti-immigrant, feelings regarding, migrants and irregular migrants and refugees and first migrants, etc. But also, I think that there's a lot to do in terms of education of migrants who are already present in destination countries. NGO do great job regarding to these topics because, for example, with irregular migrants or non-documented migrants, there's a very big myth that irregular migrants do not have rights whatsoever, or that undocumentation is equal to not having rights at all. And I think that first people need to know that's not true. And I think that we need to empower people, irregular migrants, because, for example, in terms of health, they do not go to the doctor because they are afraid to be deported. That doctors call, immigration agencies, and they are deported. So people need to know that they have basic rights, that they have human rights, and that they, that not having documents or papers is not equal to not having rights. So that's why I started my presentation with, some light theory regarding human rights, because human rights are for all, and we should stand for that principle and, try to contribute from, our work and try to comply with that, and not to discriminate people if they are forced migrant, refugees, or irregular, or whatsoever. And thank you.
Thank you so much for staying with us. I know you're not feeling well, so I really appreciate it. I know some of the students are also sick these days or have been sick. So we completely understand the situation. We will briefly tell you about the final assessment now. Please, Patty, if you want to talk about it.
Hello, can you hear me?
Yes.
Professor Camelia.
Hi.
Hello, hello, hello. Hello, everyone. Hope everyone is good. Sincere apologies for my internet connection. So I think you are hearing some blues in the background there. So I hope that it has been soothing, or even, is making the message that has been delivered today by Elisa much more even concrete. Again, thanks to Elisa for the session today. We just thought that we would spend just a few minutes today to see if we can, talk a little bit about the assessment. We know that a number of students have already been paired in groups. Some of you have actually been meeting and have gone ahead with your group assessments. And if you are not in a group, please do reach out and let us know, because you should have been in a group by now. And so for the group assessment, what has been happening is we have already submitted through the Google Classroom the names of the groups. I think have already been assigned, but actually even more importantly, a next step has been taken in which each group came up with its title. So from the different groups and the different titles that were selected, you've gone ahead to come up with your own work plans, and you've also gone ahead to decide what your research plan rather would have been. So we are only coming at this hour to give a very short announcement, which is to say that we would like to offer some mentorship support to all the 32 or 33 groups that we have. And the idea with the mentorship is that you've got quite a number of lecturers, some that you are, actually I think all that you are familiar with. Some have done lectures here, some are in the organizing committee, and the idea is for us to be able to provide some support to each of the groups. So you have one mentor assigned to each of the groups. And once this mentor has been assigned, because we have all your email addresses, we will let you know who your group mentor is, and it's up to the group and the mentor to find a date in which you will meet and explain the
We lost you again. Maybe without a video, it would be better. Okay, let's hope she's back soon. So the idea is that you will get a message later today with tomorrow maybe with your mentor. Please go ahead and write to the mentors, and afterwards we can discuss the dates as well, and all the other questions that you may have. You can ask for references or whatever questions you may have. And let's see if Paddy connects again. But yes.
Okay, all right. Apologies for that. So the idea with the group mentorship is that each of the mentors would then contact you, and you will come up together with a date which is suitable for all the group members. And we do realize this could be a bit of a challenge, but we're hoping that between the group mentors and the group mentor and the various members, you can agree on a date. And the support you need has to be defined by the group. So if the support is felt that you needed your mentor to have a read through what has already been drafted. So the idea is not that we are going to disturb your process. The idea is for us to facilitate it. We are not supervising. I think that's also very important for us to say, and we're not monitoring, but we're there to provide mentorship support. So that's why we're very careful also in the terms that we're using. And with that in mind, you would need to be very clear on the kind of support that you would need from your mentor. So let's say, for instance, you have already put your interview plan together and you would like to reach out to a certain number of people. Please let your mentor know if the support you need is to connect you to various people to be interviewed. If you just need a sound box, we are also there as mentors for us to listen through to the process and where you are. If you feel that the process that you need the mentor is not particularly where you are right now and you need to meet them later, please do let them know. But the idea is that it's on a needs basis. So we're not providing mentors so that they have a blank check, but that check has to be filled out by the different members of the group. But this is for you, and I think it would be great for you to have some interaction from one of the lecturers who will be able to walk through any kind of difficulties and also just support you with some feedback and some reflections on where you are in the process, or also, as you're going towards the preparation of those research papers. The rest of the process remains the same. So your mentor is attached to you. You will have, after that, we will have papers submitted. And indeed, the mentor will be part of the team that will be sitting to listen to the final document that will be prepared and presented before you will have a final preparation of your term paper. So with that, just to let you know, please check the Google Classroom, because all the information will be shared in there in terms of which group mentors have been assigned to which groups, in case you are not clear, or in case, as we know, a lot of people are affected by COVID in one way or another, and information may not be freely flowing. So we will share the list of mentors attached to each of the groups. Some specific emails are going out today to some groups that still haven't given us a project title. So you submitted an abstract, but you didn't give us your project title. So there are about 2 of these groups, and we'll be coming to you on that. We had 2 or 3 people who also asked for individual assessments, but we were very clear that this is a group assessment certificate program, and therefore we will not be taking individual assessments. So even those who had submitted individual assessment, we have attached you to a group, and I think you have already been informed in due course where you are. So just thought to share that with you. Otherwise, thank you so much for your commitment to the course, and thank you for being here today, and stay healthy. Thank you, Professor Camelia.
Thank you so much. There is one question here, one particular, somebody who doesn't know his group or her group, maybe he can also write on the classroom. I thought everybody know their group by now. I don't know if
Andrew, we've seen your
maybe-
request. Andrew, if you could just, if you could write an email to Rakesh, and we will be able to see it and deal with that. But I'm sure you have been assigned to a group. Thank you.
Okay. Thank you so much. See you on Saturday now. I lost the day. Thank you. Bye-bye.